Sorry, folks. We had a little technological malfunction. The internet cable fell off my computer. And so I thought I was broadcasting when I really was not. So everyone out there was looking forward to seeing something, and they didn't. But let me tell you, it was a great talk. So now this is take 2. Looks like it's live. Everything goes. Cable is all functioning. Okay, here we go again. I'm going to try this one more time. Trust. 5 little letters with a big meaning. Trust. T-R-U-S-T. Looks like it's live. Our republic and the world in general is in such a state of turmoil that confusion reigns supreme. Who you gonna trust? The government? Politicians? Science? Remember, the world is flat, they tell us. To deny it is heresy. The schools and universities? The churches? Your friends? Your family? Who you gonna trust? Now, biblical Christians already know the answer. Just checking that internet cable again. Trust. What happens without it? I'll tell you what. Anarchy. And we all know that anarchy is an unstable state, which will always be replaced by a strong man and a collectivist oligarchy. Bye-bye to God-given natural rights and liberties. Bye-bye to our constitutional republic. I hate to be considered a nattering nabob of negativism, but you haven't seen anything yet. The confusion and anarchy is going to get much, much worse. Yes, much, much worse. But Hoosiers, do not despair. There is a way out of this mess. There is a path forward. And of course, that is the Constitution solution. Hello, I'm Dr. Chris McGarrah from Warsaw, Indiana, with yet another episode of the Constitution Solution. Checking again. I think it's working. In the last few episodes, we have been examining the Indiana Constitution. So far, we have made it through the first 6 articles, and now we will move on to Article 7, Judicial. Remember, we are now concentrating on the Indiana Constitution because the federal government in Washington is temporarily a lost cause. We have enacted a strategic retreat to the borders of the sovereign state of Indiana and are manning Firewall, Indiana against the unconstitutional incursions of the massive progressive federal administrative state. We will prevail. We will prevail, but the road ahead will be difficult. Before moving to Article 7, I would like to remind you of a few things. For one, when you encounter a politician or government official who opposes your God-given natural rights and liberties, I want you to always remember the thoughts of founder James Otis Jr. To paraphrase, men oppose liberty for one or more of 3 basic reasons: pragmatism, malice, or ignorance. Pragmatism, malice, or ignorance. Keep those reasons rolling around in your thoughts. The other maxim that I want you to remember is the 3-question rule formulated by the late Georgia Congressional Representative Larry McDonald, MD. When considering the merits of any bill, act, or resolution, the elected official must ask these 3 questions in this specific order. Number 1, is it constitutional? Number 2, can we afford it? Number 3, do we need it? That being said, let's move on to Article 7, Judicial. Why do we need a judiciary? Good question. As best as I can tell, an organized civil law code goes way back to the ancient Egyptians at about 3000 BC. The norms and traditions of society were codified and enforced. Of course, then you have the ancient Greeks, the ancient Romans, and about 1,000 years of English common law. Again, briefly, why do we need an independent judiciary for the proper functioning of a constitutional republic? In his 1765 commentaries, William Blackstone said, and I quote here, "In this distinct and separate existence of the judicial power in a peculiar body of men, nominated indeed, but not removable at pleasure by the crown, consists of one main preservative of the public liberty." One main preservative of the public liberty, which cannot subsist long in any state unless the administration of common justice be in some degree separated from both legislative and from the executive power. And then there is Chief Justice John Marshall's opinion in the 1803 Marbury versus Madison case. And I quote Justice Marshall, "It is emphatically the province and duty of the judicial department to say what the law is." Let me repeat that. It is emphatically the province and duty of the judicial department to say what the law is, end quote. Last night I read and reread Marbury versus Madison. And I can tell you that to this day, it still triggers the argument concerning the existence of the concept of judicial review versus the concept of judicial supremacy. But let's not dwell on that. Let's get down to the Indiana Constitution, Article 7, Judicial. As before, I am reading from the Constitution of the State of Indiana, annotated by Andy Horning, Horning, 2010. Remember that Indiana has had two constitutions, the original from 1816 and the second and current version from 1851, with amendments since then. Most notably, there are many amendments to Article 7 from 1970. The judicial section took up 1 1/2 pages in 1816, 2 pages in 1851, and 4 pages currently. Is this progress? You decide. Okay, let me find judicial. Sorry, since this is take 2, all the papers here are in disarray. Okay, some of this is very dry, tedious, but it is the Constitution of your state. You need to know it. Article 7, Section 1, Judicial Power. The judicial power of the state shall be vested in one Supreme Court, one Court of Appeals, circuit courts, and other such courts as a General Assembly may establish. Amended, 1970. Section 2, Supreme Court. The Supreme Court shall consist of the Chief Justice of the state and not less than 4 nor more than 8 associate justices, a majority of whom shall form a quorum. The court may appoint such personnel as may be necessary. So since the 1816 Constitution, we have had 3, 5, and now 9 justices of the Supreme Court. Section 3, Chief Justice. The Chief Justice of the state shall be selected by the Judicial Nominating Commission. Notice there's no governor involved here, no electorate. Now we have, since 1970, a Judicial Nominating Commission from the members of the Supreme Court. And he shall retain that office for a period of 5 years, subject to reappointment in the same manner, except that A member of the court may resign the office of Chief Justice without resigning from the court. During a vacancy in the office of Chief Justice caused by absence, illness, incapacity, or resignation, all powers and duties of that office shall devolve upon the member of the Supreme Court who is senior in length of service, and if equal in length of service, the determination shall be by lot until such time as the cause of the vacancy is terminated or the vacancy is filled. I'm telling you, this is what happens when they write this stuff. Cable is still plugged in. I think we're good. The Chief Justice of the state shall appoint such persons as the General Assembly by law may provide for the administration of his office. The Chief Justice shall have prepared and submit to the General Assembly regular reports on the condition of the courts and such other reports as may be requested. Amended 1970. Section 4. The Supreme Court shall have no original jurisdiction except in admission to the practice of law, discipline or disbarment of those admitted, the unauthorized practice of law, discipline, removal, and retirement of justices and judges, supervision of the exercise of jurisdiction by the other courts of the state, and issuance of writs necessary or appropriate in aid of its jurisdiction. The Supreme Court shall exercise appellate jurisdiction under such terms and conditions as specified by rules, except that appeals from a judgment imposing a sentence of death shall be taken directly to the Supreme Court. The Supreme Court shall have in all appeals of criminal cases the power to review all questions of law and to review and revise the sentence imposed. So again, original jurisdiction, appellate jurisdiction, questions of law, those are important things. You may not understand them, but believe me, your ancestors or those people in the founding generation, they understood this. They understood it well. So, let's move on. Again, please stay with me. This is all very important. Section 5, the Court of Appeals. The Court of Appeals shall consist of as many geographic districts and sit at such locations as the General Assembly shall determine be necessary. Each geographic district of the court shall consist of 3 judges. The judges of each geographic district shall appoint such personnel as the General Assembly may provide by law. There were no courts of appeals in 1816 and 1851. This was all added in 1970. Section 6, jurisdiction of Court of Appeals. The court shall have no original jurisdiction except that it may be authorized by the rules of the Supreme Court to review directly decisions of administrative agencies. Now that's really interesting. The appeals court may be authorized by rules of the Supreme Court to review directly decisions of administrative agencies. So, for instance, if the Department of Natural Resources or the Health Department does something that is challenged, I guess it can go to the Court of Appeals. They have original jurisdiction in reviewing this. In all other cases, it shall exercise appellate jurisdiction under such terms and conditions as the Supreme Court shall specify by rules, which shall, however, provide in all cases an absolute right to one appeal and to the extent provided by rule, review, and revision of sentences for defendants in all criminal cases. Amended 1970. Again, did you expect that things written about the judiciary were going to be short and sweet? No. Section 7, judicial circuits. The state shall from time to time be divided into judicial circuits, and a judge for each circuit shall be elected voters thereof. Oh, finally, the voters get a say in this. He shall reside within the circuit and shall have been duly admitted to practice law by the Supreme Court of Indiana. So you must be a lawyer in order to be a circuit court judge. He shall hold his office for the term of 6 years if he so long behaves well. Well, finally, now we have the behaves well clause back in this. And Andy Horning makes a note. Please notice the phrase, if he so long behaves well. Don't let any politician cry about activist judges when they're denying their role as inactivist legislative and executive politicians. Bad judges making unconstitutional and bad decisions should be impeached. That's according to Andy Horning. Moving on, Section 8, Circuit Courts. The circuit court shall have such civil and criminal jurisdiction as may be prescribed by law, 1970. Section 9, here we go, the judicial nominating condition. Did you ever wonder what replaced the governor here and the electorate? I shall explain. There shall be one judicial nominating condition for the Supreme Court and Court of Appeals. This commission shall, in addition, be the Commission on Judicial Qualifications for the Supreme Court and Court of Appeals. The Judicial Nominating Commission shall consist of 7 members, a majority of whom shall form a quorum, one of whom shall be the Chief Justice of the state or a Justice of the Supreme Court whom he may designate, who shall act as chairman. Those admitted to the practice of law shall elect 3 of their members to serve as members of said commission. So that means that the lawyers of Indiana get to elect themselves as the only electorate, 3 of their members, 3 lawyers to sit on this judicial nominating commission. All elections shall be in such manner as the General Assembly may provide. The governor, here we come back to the governor. Power number 15 to my count of the governor. The governor shall appoint to the commission 3 citizens. Hey, we finally get a say in this. 3 citizens not admitted to the practice of law. The terms of office and compensation for members of a judicial nominating commission shall be fixed by the General Assembly. No member of a judicial nominating commission other than the Chief Justice or his designee shall hold any other salaried public office. No member shall hold an office in a political party or organization. No member of the Judicial Nominating Commission shall be eligible for appointment to a judicial office so long as he is a member of the commission and for a period of 3 years thereafter. I told you this was bone dry, but it's amended 1970. So you had the Hoosiers and legislatures of 1970 to thank for this. Section 10, selection of justices of the Supreme Court and judges of the Court of Appeals. A vacancy in a judicial office in the Supreme Court or Court of Appeals shall be filled by the governor, without regard to political affiliation, from a list of 3 nominees presented to him by the Judicial Nominating Commission, power number 16 of the governor. If the governor shall fail to make an appointment from the list within 60 days from the day it is presented to him, the appointment shall be made by the Chief Justice or the acting Chief Justice from the same list. To be eligible for nomination as a Justice of the Supreme Court or Judge of the Court of Appeals, a person must be domiciled within the geographic district, a citizen of the United States, admitted to the practice of law in the courts of the state for a period of not less than 10 years, or must have served as a judge of a circuit, superior, or criminal court of the state of Indiana for a period not less than 5 years. November 3rd, 1970. Has this disenfranchised voters? That's just my annotation. Here is a big, long section, but we're getting close to the end. After this, everything is just little one-liners. Tenure of justices of Supreme Court and judges of the Court of Appeals. A justice of the Supreme Court or judge of the Court of Appeals shall serve until the next general election following the expiration of 2 years from the date of appointment and subject to the approval or rejection by the electorate. That's you. Shall continue to serve for terms of 10 years so long as he retains his office. In the case of a justice of the Supreme Court, the electorate of the entire state shall vote on the question of approval or rejection. So you do get a say in retaining them. In the case of judges of the Court of Appeals, the electorate of the geographic district in which he serves shall vote on the question of approval or rejection. every such justice and judge shall retire at the age specified by statute in effect at the commencement of his current term. So maybe that's good. Maybe no more Ruth Bader Ginsburg's here in Indiana. Every such justice or judge is disqualified from acting as a judicial officer without loss of salary while there is pending, number one, an indictment or information charging him in any court in the United States with a crime punishable as a felony under the laws of Indiana or the United States, or two, a recommendation to the Supreme Court by the Commission on Judicial Qualifications for his removal or retirement. On recommendation of the Commission on Judicial Qualifications or on its own motion, the Supreme Court may suspend such justice or judge from office without salary when in any court in the United States he pleads guilty or no contest or is found guilty of a crime punishable as a felony under the laws of Indiana or the United States, or of any other crime that involves moral turpitude under that law. Now, moral turpitude, what does that mean? Whose moral turpitude? Biblical Christianity, or the amoral behavior of today? Well, I guess no one's challenged that. If his conviction is reversed, suspension terminates and he shall be paid his salary for the period of suspension. If he is suspended and his conviction becomes final, the Supreme Court shall remove him from office. On recommendation of the Commission on Judicial Qualifications, the Supreme Court may, one, retire such justice or judge for disability that seriously interferes with the performance of his duties and is or is likely to become permanent, and two, censure or remove such justice or judge for action occurring not more than 6 years prior to the commencement of his current term, when such action constitutes willful misconduct in office, willful and persistent failure to perform his duties, habitual intemperance, or conduct prejudicial to the administration of justice that brings the judicial office into disrepute. Boy, that was a long sentence. A justice or judge so retired by the Supreme Court shall be considered to have retired voluntarily. Well, how nice for them. A justice or judge so removed by the Supreme Court is ineligible for judicial office, and pending further order of the court, he is suspended from practicing law in the state. Upon receipt by the Supreme Court of any such recommendation, the court shall hold a hearing at which such justice or judge is entitled to be present and make such determinations as shall be required. No justice shall participate in the determination of a hearing when it concerns himself. The Supreme Court shall make rules implementing this section and provide for convening of hearings. Hearings and proceedings shall be public upon request of the justice or judge whom it concerns. No such justice or judge shall, during his term in office, engage in the practice of law, run for elective office other than a judicial office, directly or indirectly make any contributions to or hold any office in a political party or organization, or take part in any political campaign. Amended 1970. Now, the rest of these are basically one-liners, so stick with me. Thank you for putting up with all that stuff, but you need to know how your Indiana judges and Supreme and Appellate Court justices are selected and retained, because I bet most of you didn't know. Section 12, substitution of judges. The General Assembly may provide by law that the judge in one circuit may hold the courts of another circuit in cases of necessity or convenience, and in case of temporary inability of any judge from sickness or other cause to hold the courts in his circuit. Provision may be made by law for holding such courts. 1970. Section 13, removal of circuit court judges and prosecuting attorneys. Any judge of the circuit court or prosecuting attorney who shall have been convicted of corruption or other high crime may, on information in the name of the state, be removed from office by the Supreme Court or in such other manner as may be prescribed by law. Here's an easy one, Section 14. It was repealed, 1984. What was Section 14? The office of Justices of the Peace. We no longer have those. That was easy. Section 15, no limitation on term of office. The provisions of Article 15, Section 2, prohibiting terms of office longer than 4 years, shall not apply to justices and judges, as amended 1970. Section 16, prosecuting attorneys. There shall be elected in each individual circuit by the voters thereof a prosecuting attorney who shall have been admitted to the practice of law in the state before his election, who shall hold his office for 4 years, and whose term of office shall begin on the first day of January next succeeding his election. The election of prosecuting attorneys under this section shall be held at the time of holding the general election in the year 1974 and each 4 years thereafter, as amended 1970. Grand jury, Section 17. The General Assembly may modify or abolish the grand jury system, 1970. Section 18, criminal prosecutions. All criminal prosecutions shall be carried on in the name and by the authority of the state, and the style of all process shall be, quote, the state of Indiana, end quote. Section 19, pay. The justices of the Supreme Court and judges of the Court of Appeals and the circuit courts shall at stated times receive compensation which shall not be diminished during their continuance in office. That one was amended in 1971. Section 20 was repealed. That's another easy one. What was Section 20? Well, that was a provision in the 1851 Constitution which established a commission to revise the courts, the rules, the infrastructures, sort of bring it up to the standards. Well, they finished their job, so it was dissolved. Section 21 was repealed. Now, what was Section 21? Well, it was repealed in 1932, but the original wording of Section 21 was as follows. Every person of good moral character, being a voter, shall be entitled to admission to practice law in all courts of justice. So until 1932, you could practice law by just being of good moral character and being a voter. I'm not exactly sure what good moral character would mean today. No, we'll just leave it at that. And that is it, Hoosiers, for your judicial branch, Article 7. Are they guardians of your God-given rights or power-usurping oligarchs in black robes? You decide. Before concluding this evening, allow me to quote a few passages from founder Thomas Jefferson with respect to the federal judiciary, but you could infer some things about state Supreme Courts. Now, as you remember, Jefferson was not particularly keen on the Supreme Court. I'll try to be brief here. So Jefferson said, the Constitution on this hypothesis is a mere thing of wax in the hands of the judiciary, with which they may twist and shape into any form they please. It should be remembered as an axiom of eternal truth in politics that whatever power in any government is independent is absolute also. In theory only at first, while the spirit of the people is up, but in practice as fast as that relaxes. Independence can be trusted nowhere but with the people in mass. They are inherently independent of all but moral law. My construction of the Constitution is very different than that you quote. This was in a letter. It is that each department is truly independent of the others and has an equal right to decide for itself what is the meaning of the Constitution in cases submitted to its action, and especially where it is to act ultimately and without appeal. So you can see Jefferson felt that each independent department could interpret the Constitution. Well, you think about that. That's pretty far reaching. Let me go on to skip a few sections here because the hour is late. And in this letter, Thomas Jefferson concludes, the germ of dissolution of our federal government is in the constitution of the federal judiciary, an irresponsible body, for impeachment is scarcely a scarecrow, working like gravity by night and by day, gaining a little today and a little tomorrow, and advancing its noiseless step like a thief over the field of jurisdiction until all shall be usurped from the states and the government of all be consolidated into one. Whoa. Tell us how you really feel about the judiciary, Mr. Jefferson. So again, this is for you to decide, Hoosiers, how you feel about the judiciary. That was Section 7, how they are selected, retained, and their duties. Now, you're not going to want to miss the next episode of the Constitution Solution, 7 p.m. Thursday, June the 24th, when the subject will be Article 8, Education. Education. And the Indiana Constitution. Are we currently having issues with education in the state of Indiana? I think so. So you'll be interested to see what the Constitution of Indiana has to say about education. Well, Hoosiers, as we sign off tonight, I want you to remember doctor's orders. Remember, wash your hands. Don't touch your face, but above all, keep your distance. Keep your distance from those socialist, statist, globalist, collectivist politicians and bureaucrats, because Hoosiers, now you know exactly who they are. The curtain has been pulled back and no longer hide from you, the people. Like they say on JBS Constitution Corner, don't just know your Constitution, live it. Well, I'm sorry about the technical glitch. I will see you next time. Thank you. I sincerely hope this works because I don't want to do take 3.